Good afternoon, everybody. I'd like to welcome you to the McGowan Theater, located in the National Archives building in Washington, D.C. I'm Doug Swanson, Visitor Services Manager for the National Archives Museum, as well as the producer for these noontime lectures. I have a couple of brief announcements before we bring today's author on stage. This evening, September 30th at 7 p.m., Tim Gunn, star of Project Runway, will moderate a discussion and fashion show, 1920s-style Prohibition-era fashion. If you plan on attending, you're invited to dress in 1920s period-style clothing, but it's not required. On Friday, October 2nd at noon, historian Erica Lee will return to the National Archives for a talk on her latest book, The Making of Asian America, A History. And then also on October 2nd, but at 7 p.m., we'll be screening a film about a dark and little-known chapter of America's recent political past, Uniquely Nasty, the U.S. government's war on gays. To find out more about these and our other programs and exhibits, please take one of our monthly event calendars, which you'll find in the racks out in the theater lobby, or you can visit our website at www.archives.gov/calendar. Our topic for today is The Constitution, an Introduction by Michael Stokes Paulsen. Michael Paulsen is the Distinguished University Chair and Professor of Law at the University of St. Thomas, where he's taught since 2007. Professor Paulsen was previously the McKnight Presidential Professor of Law and Public Policy and Associate Dean at the University of Minnesota Law School, where he taught from 1991 to 2007. He's a graduate of Northwestern University and Yale Law School and has served as a federal prosecutor, as attorney advisor in the Office of Legal Counsel of the U.S. Department of Justice, and as counsel for the Center for Law and Religious Freedom. Professor Paulsen is the author of more than 90 scholarly articles and book chapters on a wide variety of constitutional law topics. In addition to The Constitution, an Introduction, co-authored with Luke Paulsen, Professor Paulsen is co-author of the case book, The Constitution of the United States, along with Steve Calabresi, Michael McConnell, and Samuel Bray, and editor of Our Constitution, Landmark Interpretations of America's Governing Document. Please join me in welcoming Michael Paulsen to the National Archives.
Well, thank you all very much. It is an honor and pleasure to be here. Coming back to Washington, D.C. is like coming home for me. This is homecoming. In fact, this morning I drove by my wife's and my old apartment in Arlington just to walk through the grounds one more time. I lived here from 1985 to 1991. One of my colleagues at U.S. Department of Justice is actually lurking in the audience there with you right now. D.C. is a special place for me. It's where I met my wife, just actually a few steps away from here in the summer of 1984. Yes, it was just like, I think it was 9th in Constitution, and so this is a special place for us. I left in 1991. My kids are Minnesotans. They think Minnesota is the center of the universe. I try to remind them every now and then that there are other places to live and to work, and it's really a pleasure to be here, and especially honored to be able to appear at the National Archives. It's a really special place. They do great programs, and I thank Doug and the others so much for their hospitality. Truly grateful for this opportunity. As Doug mentioned, I'm one half of the co-author team of this book, The Constitution, an Introduction. The other half is my son, Luke, who's 23 years old, and a software engineer in Silicon Valley, California. We've given a version of this presentation at Stanford University on the West Coast, but he has a real day job. I'm just a law professor. I can show up wherever I want. So he was unable to come here, but I really want to give him full credit. It is really an absolute team effort, a genuinely co-authored book, and I kind of want to just tell the story of how it came to be. It started about 10 years ago. I was at an academic conference, and after academic presentations, everybody gets together, the professors and their sponsors and everything, and they have a dinner or something like that. Around about the second bottle of wine, an argument broke out between the college professors who were there and the law professors as to when their students had developed such misshapen ideas about the Constitution. Where did they get all these wrong-headed ideas? And the law professors, of course, blamed the college professors, right? What are you teaching these kids? And the college professor said, no, not our fault. Don't blame us. They come to us this way with ideas that have come to them through textbooks, through popular media. It's sort of pervasive in the culture, and undoing and untangling these mistaken ideas is not a day's work, and it can't be accomplished in a single semester. It's not our fault. It's not our fault. And I improvidently ventured, I said, well, somebody really ought to write a book that's aimed at real people. And they said, well, why don't you do that instead of writing all your boring law review articles? And this was out in New Jersey, and I was flying in and out of Philadelphia, which seems an appropriate place to get an idea about a book on the Constitution. And the next day, flying home, I was bumped from my flight in Philadelphia, and I had about 3 hours extra time sitting around the airport with a yellow legal pad, and I just went to a coffee shop, and I said, well, if you were trying to write a straight-ahead, simple, straightforward book on the Constitution and make it short and concise and clear, what would be its essential elements? And I actually found this yesterday before flying here, the 2 sheets of legal pad paper in which this is the outline of the book. This is the whole book right here, written in the Philadelphia airport. And the general scheme was that it would be 10 chapters. The first chapter's on the origins and basic content of the Constitution. And it's pretty much the way the book is spun out. Chapter 1 is on the Constitutional Convention, the forces that led to the creation of the Constitution and how it came to be. Chapter 2 is sort of on the great themes of the Constitution, the idea that it's a written Constitution, ideas of separation of powers and federalism and Republican government. We have Chapter 3 is on the powers of the national government. Chapter 4 is on slavery. You can't talk about the original Constitution without talking about slavery. And Chapter 5 is on the Bill of Rights, which we said was sort of the second half of the original Constitution, or the completion of the original Constitution. The Bill of Rights, as you probably well know, was adopted fast on the heels of the Constitution as a necessary corrective of some of the concerns about an overbroad national government and how it could intrude on individual rights, and also as a way of assuring those who dissented from the Constitution that their concerns were going to be taken into account and embodied in the original Constitution. So that's our first half of the book, is just laying out the Constitution's origins, purpose, provisions, and basic content. And then the second half of the book, we have 5 more chapters dealing with the history of the Constitution's interpretation from its early implementation in 1789 up until 2015. The book went to bed in January or February 2015 when it went to the printer. And so we have a chapter on the early controversies of the Constitution. That's Chapter 6. And a lot of what I'll be talking about today is from Chapter 6. Chapter 7 is on Lincoln, the Civil War, and the crisis over constitutional interpretation that produced the Civil War and resulted from the Civil War. Chapter 8 is covering a broad spectrum of time from the end of Reconstruction to the middle of the 20th century, a period we call betrayal because it seems like the Supreme Court didn't get much of anything right between 1870 and mid-1930s. A few things, but there was really a bad period in constitutional interpretation. Chapter 9 covers the middle of the 20th century. We call that chapter Restoration. And Chapter 10 is this hugely ambitious attempt to distill everything that's happened in constitutional law from 1960 to 2015, the modern era, and we call that controversy, which is appropriate because the Constitution has been, for the past 50, 60 years, a source of enduring modern controversies. So that was the outline of the book, and it actually still really continues to hold true to that form. I brought that outline home that night. I was a little late getting home, so Luke, who was 13 at the time, had to be responsible for babysitting his sister, who was 7 at the time. But that night, I showed Luke the outline, And, he was interested in constitutional law because for many years, when driving him and his sister to school, he would warm me up for teaching. Daddy, what are you teaching about today? And so, I hope it isn't a form of child abuse, but by age 14, he could tell you about the legal doctrine of offensive non-mutual collateral estoppel and other really easy mouthfuls like that. Child Protective Services was never summoned. And he actually developed an interest in these sort of things so that by the time he got to 8th grade in his civics books, he could spot the flaws. He'd say, Dad, look at this. They say the Supreme Court created the doctrine of judicial review, and the Constitution is whatever the Supreme Court says it is. And we'd share a good nerdy belly laugh together about these sorts of things. He was able to spot some of the conventional myths really early on. So I presented this idea to him and said, would you like to work together with me on it? Maybe we'll write a simple book in one summer that'll be the corrective to everything that's taught wrong in junior high and high schools, and it'll be for general readers too. And he said, sure, that sounds, so he's 13 at the time. And we thought it would be a one summer project and that it would be a better way of giving him a summer job than mowing lawns or flipping burgers. We actually struck a deal that we'd share any royalties 50-50. We've stuck to it. He doesn't need it now. He's a software engineer and a Princeton University graduate. He's making an honest living. But we had no idea that it would become a 9-year odyssey. We thought it would be a one summer project, but we weren't done. And we put it away when the school year started. We were both too busy to keep going forward with these sort of things. And we started returning to it each summer. Where was it we left off? Oh, we're on chapter 3 now, right? And over time, the book took shape, became gradually more and more sophisticated, but we are still trying to hew very closely to this idea of it being readable, accessible for general readers. He worked really hard, and I think successfully, to cure me of professoritis, the tendency to go on and to get too jargonistic or too technical and lawyery. By the time we were finished, it was genuinely co-authored because we'd each rewritten each other's work so many times. And the book is interspersed with little portrayals of some of the important figures in our nation's constitutional history. Everything from Alexander Hamilton to Frederick Douglass to the real Jane Roe to Richard Nixon. Many of these constitutional controversies have stories and persons attached to them, and Luke was responsible for writing the initial first drafts of those. So what we ended up with is something sort of like what we started to do. Our hope, our humble hope, is that it would really serve as kind of the definitive introduction, the first book that you recommend to someone if someone is interested in the Constitution, doesn't have a background in it, this would be a good place to start. There are many, many books on the Constitution. We don't purport for this to be the last word or the ultimate answer to everything, but it is an attempt to introduce many of the debates, many of the controversies. We take some positions, but where it differs from the conventional, we sort of lay that out and try to leave it for readers to judge for themselves. So that's the book. That's enough of a commercial for the book. I guess it's going to be available for purchase and signing. In fact, when we were conceiving of this book, I said, here's the test. We're trying to figure out who this book is for. I said, someday I want to see this book in the bookstore of the National Archives. That's the test. So this is actually living out the goal perfectly. I had distributed a handout to sort of a rough outline because I was trying to figure out exactly how to talk about these things in an engaging way. When I talk with students about constitutional history, they often tend to go, yeah, that was a couple hundred years ago. How does it affect anything today? Okay, and my title for this talk is All This Has Happened Before, with the subtitle, The Supreme Court's 2015 Landmark Cases in Historical Perspective. And the idea is, that many of the controversies that so preoccupy our nation today in terms of constitutional interpretation are rehashes or reprises or echoes of controversies that have come long before. You could have titled this a number of things. For those who like the book of Ecclesiastes, you might have said there's nothing new under the sun. Well, that's not quite accurate. These are sort of new versions of old controversies. For the baseball fans or the devotees of the late Yogi Berra, you'd say this is deja vu all over again, right? But basically the idea is that what we see today in some of these hot controversies are things that can be better understood if you understand the constitutional past. And you can see, oh, this is just like Alexander Hamilton and Thomas Jefferson arguing over whether the government has the power to create a national bank. So that's my theme today. I'm going to tell 3 sets of stories. And the old versions of the stories all come from chapter 6. And the new versions that parallel these stories come from some of the most recent and interesting Supreme Court controversies, including a couple from just this past year. So there will be 3 broad stories that I'm going to tell. The first is about an issue that is of enduring significance, the scope of national legislative powers. How broad are the powers of Congress vis-a-vis the powers of the state? And my pairing there is Hamilton versus Jefferson advising President Washington over the Bank of the United States. And then the modern echo of it is one that I think you may have heard of, Obamacare. So, okay. Then the second story will be about the battle between Congress and the president over who has primacy, constitutional primacy in the area of foreign affairs. That's a familiar and enduring controversy. And then finally, I'll conclude with a couple of stories about the First Amendment freedom of speech in the press, an issue that continues to be of vital importance to Americans interested in their freedom. And it's as alive today as it was in the 1780s and 1790s. So those are my 3 stories. The first one concerns the scope of national legislative power. And my pairing is Alexander Hamilton and Thomas Jefferson in 1789 with Obamacare. Okay, let me set the stage. It's the Washington administration, and Washington's very enthusiastic, energetic Secretary of Treasury is the young Alexander Hamilton, who is just headstrong, wicked smart, and a firm defender of national government power in order to create a unified nation. Okay? Washington's Secretary of State is the states' rights-oriented Thomas Jefferson. Okay? Hamilton, as Secretary of Treasury, comes up with certain plans to put the finances of the United States on a secure basis. And a way of accomplishing that is we need to create a Bank of the United States with lending power as a means of collecting the debts, of a means of paying the debts and levying taxes. We're going to create a Bank of the United States. The question immediately arose, can Congress do that? Can Congress create a national bank? There's no specific national bank clause power in Congress's list of enumerated powers. And immediately, the interpretation of the Constitution in 1789, like right away after it's been ratified and before the Bill of Rights has even become part of the Constitution, there's this big debate over how broad are the powers of the national government. On the one hand, it is a government of limited enumerated powers. All right, that's still true, is that Article 1, Section 8 of the Constitution lists Congress's power. And the Congress, in theory, can't just do anything it wants. It has to be implementing some power on the list. So it is a government of limited powers. That's sort of the Jeffersonian perspective. At the same time, those powers are limited, but they're often written in pretty broad, sweeping language, expansive terms that enable a lot of room for interpretation and application over different years. And that was the Hamiltonian position. He says, yeah, it's a government of limited powers, but look at how broad these powers are. Power to regulate state commerce among the states and with foreign nations. The necessary and proper clause power to carry into execution all of the foregoing powers, which implies that Congress has a substantial discretion over the choice of means of accomplishing its ends. Okay. and in a famous pairing of opinions that are presented to President Washington, and I put these in the constitutional law casebooks that law students read too, these arguments are laid out. And the thing is, they're both right. It is a government of limited powers, and the powers that are limited are written in broad, expansive terms. Washington sides with the Hamilton view and approves and signs the bill establishing the Bank of the United States. So the Hamilton view early on wins out in terms of the scope of the government's broad national powers. Now, it's not a win that is like a forever win, right? And these arguments about the scope of national powers have emerged and continued throughout our nation's history. And that brings us up to present day, right? Just a few years ago, in 2012, there was this enormous constitutional decision by the Supreme Court in what's called the Obamacare case. The case name is NFIB, National Federation of Independent Business, versus Sebelius, who was the Secretary of Health and Human Services. And it involved the question of whether Congress could, pursuant to its commerce power, its taxing power, and the necessary and proper clause power, create an individual mandate that everybody purchase health insurance. I'm talking to you like you don't know what, you're not familiar with this. I'm sure that most people are familiar with this controversy. It was hard to avoid it at the time. But the question was whether Congress actually had the power to compel people to purchase a product on pain of paying a penalty or fine to the IRS as part of their taxes if they didn't do it. And the Supreme Court in that case basically echoed the arguments of Hamilton versus Madison on the scope of national powers, and it came up with this interesting split. A majority of 5 justices said the Commerce Clause power could not give Congress the authority to require people to engage in commerce, or else it would become just total circular bootstrap and Congress could justify anything it wanted to adopt. Similarly, the necessary and proper clause couldn't be used to get around the intrinsic limits to the commerce power. So the actual part of the holding of that case is that Obamacare could not be justified as a regulation that Congress could just impose. Okay? It did not have power to just directly require it. But the Obamacare requirement was styled as if you do not purchase health insurance, you are subject to a penalty, which is payable to the IRS as part of your taxes. And a different 5-4 majority of the Supreme Court said, you know, you can actually sustain the exercise of this individual mandate requirement as an exercise of the taxing power. Yes, the politicians scrupulously avoided calling it a tax. They called it a penalty, but political false advertising can't take away a true constitutional power, and so this was actually within Congress's constitutional power to enact. The interesting thing, I think, is that this is just a recreation in slightly different forms, modern version of the Hamilton versus Jefferson debate. Now, the court had another Obamacare decision this past term, and it's not nearly as interesting. It was a question of interpretation of the statute. What is an insurance exchange established by the state? Established by the state. And interestingly enough, and highly controversial, the Supreme Court said that an exchange established by a state includes an exchange not established by a state, but established by the federal government. And on that interesting and admittedly somewhat convoluted argument, turned billions of dollars of federal financial assistance. That's the Burwell versus, the King versus Burwell case decision from last term. Enough of that controversy. The second pairing that I want to talk about for a few minutes concerns the scope, the division of power between Congress and the president over the foreign affairs, okay? So this is a pairing of Washington's neutrality proclamation. You all remember that? No, that's probably not a prominent, some do remember it from their history books, with a Supreme Court decision this past term called Zivotofsky versus Kerry. Zivotofsky is the name of the plaintiff. It's Menachem Binyahim Zivotofsky, who was a 13-year-old boy who was born to U.S. citizens, but while living in Jerusalem. The specific issue in the Zivotofsky case was whether Congress could require that a passport issued to a U.S. citizen born in Jerusalem say Jerusalem, Israel, as opposed to just saying Jerusalem, which was what the presidential administrations wanted, because the presidential administrations wanted to straddle the issue and avoid being direct about the question of who has sovereignty over Jerusalem, because it was a controversial hot-button issue in the Middle East. And so, like all good politicians, the way to avoid a difficult issue is to try to take an ambiguous stand on it. And so they said, we wanted the passport to just say Jerusalem. It's a passport, okay? But Congress had passed this statute saying, if you're a U.S. citizen born in Jerusalem, you're entitled to have the word Israel put on there. It's kind of Congress taking a side on the position of Israel's sovereignty and sort of doing it with what powers they had over passport regulation. Well, of course, the issue that this reminds me of is Washington's Neutrality Proclamation, which is the instance early in our nation's history that involved the first big dispute over the question of who has the foreign affairs power and how far does it go and when does the president infringe upon Congress's powers when the president exercises a foreign affairs policy decision. So here's what happened. It's 1793 and France and Britain are at war again. It's like the third time in 30 years that France and Britain are at war, and President Washington, who was first in war, wants to be first in peace. He thinks it's a really bad idea for the United States to get involved in this foreign war. We'll get our butts kicked. It won't be good for the nation. Peace. So let's stay out of this. The problem is we had a treaty that appeared to be a mutual defense treaty with France dating to the days of the American Revolutionary War. Benjamin Franklin had gone over to France and wined and dined the French nobility and kings and basically produced a treaty of amity and friendship and mutual defense that was instrumental in American independence when France, with its naval power, came to our aid and helped us win independence. Now, it's a number of years later, there's been a change in the French regime. A few heads have rolled, literally, okay? And it's a different situation. And the question is, are we bound by our mutual defense treaty with France to come to its aid now in a new war with Britain? Okay? And Washington determined that it was going to be the policy of the United States to stay out of the war, and he issued a neutrality edict. This was controversial with Congress. What gives the president to do that? We thought we had the power to declare war. The power to declare war means we get to decide whether we're going to war or not. You can't just on your own, Mr. President, make a foreign policy decision as to the meaning and effect of a treaty and whether you will adhere to it, whether you will construe it narrowly, whether you will terminate the treaty. You can't just go off and do that. Again, it's Alexander Hamilton that provides the legal analysis, the constitutional analysis for President Washington. And it's an early and very instructive and very influential defense of what Washington's done. He publishes it under the pseudonym Publius in a series of newspaper editorials, basically, newspaper columns. And Hamilton's position is basically this. The president is given the executive power. The executive power was always understood to include not just execution of laws, but the power to formulate, devise, and carry out the nation's external relationships in all matters. Now, traditionally, the executive power over foreign affairs was a power of the king and included the power to declare war and to raise armies. Those powers were specifically relocated to Congress under the Constitution. There were certain foreign affairs powers we took away from the president, but then there were provisions put into Article 2 of the Constitution to clarify that the president retained the executive power and retained essentially the traditional executive power over foreign affairs, except where it had been removed. Highly influential position. Hamilton's position, of course, buttressed Washington's, and that's the policy that was implemented. Now, fast forward to today and the Zivotofsky case, the passport case. I think the right answer is that the president has the power over foreign affairs as an aspect of the original meaning of the executive power, and to the extent that is the president's power, Congress may not, through the exercise of any of its other collateral powers, infringe upon the president's power in foreign affairs, other than the areas where it is explicitly removed and put in Congress's hands. Now, the right answer to the Zivotofsky case, then, I think, is that it is actually unconstitutional for Congress to require the executive, in effect, to take a position on the sovereignty of Jerusalem, whether it's Israel or not, that the president does not wish to do. That is the result of the majority opinion of the Supreme Court, written by Justice Kennedy, though I kind of think he botched the legal analysis. The legal analysis is all over the place and just very confusing and convoluted. There's a concurring opinion by Justice Clarence Thomas, which is, I think, the only opinion that gets the constitutional analysis just about perfectly right, and it tracks almost letter by letter Alexander Hamilton's analysis as Publius back in 1793. The ultimate vote is 5 justices, Kennedy writing for himself in the more liberal wing of the court, which is an interesting development. We'll talk about that in a second. Justice Clarence Thomas concurring, and then the 3 more conservative justices other than Thomas, Chief Justice Roberts, Justice Scalia, Justice Alito, holding that an act of Congress actually can meddle with executive foreign affairs powers. Now, this is odd and weird to my sensibilities, in that traditionally it seems, at least in more recent years, that the pro-presidential power position has been one that's been advanced by the more conservative wing of the court. Certainly it was in all these Bush administration era decisions about Guantanamo, military commissions, commander-in-chief clause power. And the liberal position was usually more, Congress has a role in this. Congress can do things, the president can act alone. In the Zivotofsky case, the positions of the liberals and the conservatives are just about exactly reversed. Now, depending on how cynical you're inclined to be, you would say, well, what accounts for this? It might be that the justices' votes in the Zivotofsky case tend to line up more with their political preferences for the present day disputes. I hesitate to be too cynical on this. I'm always looking for an honest explanation, but it seems like the liberal wing of the court wished to uphold the views of the Obama administration, and the conservative wing of the court didn't, and it didn't track their usual views of the constitutional provisions at issue. And it's interesting, the Zivotofsky case was argued in March of last year, at about the same time that there's this dust-up over Netanyahu's visit. Some of you Washington insiders remember Congress invited him and the president didn't invite him. And there's this continuous pull and tug between Congress and the executive branch over who has what powers in the area of foreign affairs. My short take on it is that Zivotofsky is just a pale echo, a quaint case, of a controversy we've had since 1793, and that George Washington and Alexander Hamilton had it figured out a lot better than the Supreme Court did in 2015. My third controversy. May I take a sip of coffee to just oh, you're not supposed to bring drinks in here. I won't tell, but I guess this is going on the internet live stream, so I'm okay. The third controversy involves the freedom of speech in the press and the Alien and Sedition Acts of 1798. Okay, this actually is a continuation of the history that followed our not coming to France's side in the wars with Britain in the early part in 1793 and 1794. By the time President Washington leaves office and President Adams, the second president, takes office, our relationships with France have deteriorated to the point that we're essentially about ready to go to war with revolutionary France. And Congress passes a series of acts putting the nation on essentially on a war footing, including acts authorizing the president to kick out members of foreign nations who he thinks are disloyal, and acts, something called the Sedition Act, which makes it a crime to publish false, scandalous, or malicious writings tending to excite the hatred of the good people of the United States against their government. Okay? Now I'm pairing that with a case from 2015 called Walker versus Texas Division, Sons of Confederate Veterans, because they both involve issues of First Amendment freedom of speech. But the big deal case was in 1798 and 1799. The Sedition Act, making it a crime basically to publish critical commentary of your government, is about as clear a violation of the First Amendment freedom of speech and press as it's possible to get. And everybody today, I think essentially everybody would agree with it. The core of the First Amendment, freedom of speech, is that government may not punish, prohibit, or penalize the expression of views that it disagrees with. It may not discriminate against views. It may not impose special burden on views. People get to say what they wish to say, absent a few exceptional circumstances and exceptional categories. It's hard to think of a more clear violation of that principle than the Alien and Sedition Acts of 1798. And interestingly enough, the Sedition Act resulted in a number of prosecutions and punishments, and we tell these stories, and it's all in Chapter 6. There's a lot of content. You should buy the book just for the purpose of Chapter 6, if you like today's stories. They prosecute newspapers, pamphleteers, a cranky congressman, and satirists, some of whom did nothing much more than call President Adams a fat, pompous jerk. Okay? And these convictions are almost all upheld, and there's a constitutional challenge that is raised and argued in these situations, but the federal courts consistently get it wrong. Now, there's an interesting side issue to this, too, is like, who gets to interpret the Constitution? We modern-day Americans are so used to thinking of the Constitution as something the Supreme Court interprets, and that's true, but it is not only for the Supreme Court to interpret. The Sedition Act controversy raises the interesting problem of what do you do if Congress passes an unconstitutional law? The executive enforces and prosecutes and punishes under an unconstitutional law, and the federal judiciary consistently upholds, wrongly, the constitutionality of this unconstitutional law. Who checks the positions of the national government when the national government gets it all wrong? And part of the interesting history was that it was resistance by state officials and resistance by the people in the electoral process that changed the governing interpretation of the Constitution. By this time, Thomas Jefferson is Adams's vice president, and they're not really on the same page, if you know what I mean. Jefferson ghostwrites for the Kentucky legislature a resolution where the Kentucky legislature purports to declare unconstitutional the Sedition Acts, okay, and to nullify them and to refuse to comply with an unconstitutional action approved by all three branches of the national government. Highly interesting situation. Jefferson's buddy, James Madison, writes a similar resolution for the Virginia legislature defending the propriety of Virginia interposing its state authority to resist unconstitutional acts. Now, this is highly interesting because there are parallels even this past month in the actions of some Kentucky government official resisting what that official thought to be the wrongful actions of the government of the United States. Okay? Highly interesting question. The ultimate resolution of the Sedition Act controversies did not come by the Supreme Court overruling itself. It came in the election of 1800, where one of the issues was the constitutionality of these enactments. And the people, through the Electoral College, sided with Thomas Jefferson, who won election over Adams, reversing the outcome from the 1796 presidential election. And then Jefferson, as president, says, I'm interpreting the Constitution in a way differently from how Congress had, from how my predecessor had, and from how the courts had. And I'm going to refuse to execute what I think is an unconstitutional statute, and I'm going to grant pardons under it, setting an early precedent for independent presidential interpretation of the Constitution. Okay, fast forward briefly to today's controversy. I just love the Sons of Confederate Veterans case. The Sons of Confederate Veterans case involves a Texas state specialty license plate program. Now, in a nutshell, Texas permits private groups, clubs, businesses, individuals to design their own specialty license plates for a price. It actually costs you like $8,000, and then your members buy these plates, and they cost a lot more. It's a big money raiser for the state of Texas. Some states have their license plate slogans, but Texas has basically turned its license plate program into selling advertising space for your particular organization. So they have over 350 different types of license plates in Texas. How do you know if something's actually a Texas car? It does say Texas on it, but then none of the license plates look alike. So there are license plates promoting golfing, 4-H clubs, Mothers Against Drunk Driving, football teams. My favorite illustration is there's a Texas license plate that says, "Go Oklahoma Sooners." All right? There's a Dr. Pepper license plate. There's a hamburger stand license plate. So along come the Sons of Confederate Veterans and say, we want something honoring our veterans. You know, we're the descendants of people who fought on the wrong side of the Civil War, and it's got a tiny Confederate battle flag as part of their emblem. Well, this one, the Supreme Court says, first of all, the Texas Commission says, we won't approve that because we're offended by what you're saying. Okay? Very small ball version of the same issue presented by the Alien and Sedition Acts, right? Government is taking action against your expression because they don't like what you have to say. The stakes are perhaps a little bit lower and definitely a little less sympathetic in the situation, but it's kind of the same principle. Goes up to the U.S. Supreme Court, and the U.S. Supreme Court 5-4 upholds what Texas has done. So Texas gets to exclude from its specialty license plate program the Sons of Confederate Veterans battle flag specialty designer plate. And the reasoning, they say, is that the Texas license plates are Texas's speech. This is Texas talking. This isn't your own freedom of expression. And it's actually interesting. Government, within the context of its own programs, gets to communicate and express its views. And that's actually a correct principle, that when government speaks, that's not necessarily an interference with yours and my freedom of speech. But it becomes a little dangerous if everything that the government touches, owns, manages, curates, National Archives, edits, teaches, or controls in any way, somehow automatically everything that occurs in it becomes government speech. I'm speaking at the National Archives, but I assure you I am not speaking for the views necessarily of the government of the United States. It's a dangerous principle that if government speech applies every time the government is involved, then the scope of the freedom of speech contracts as government power expands. And that, I think, is a disturbing principle. Now, there's always line drawing questions, but it seems to me that when Texas has 350 plates, has never rejected any of them, and you can't plausibly say, I'd rather be golfing, is Texas's desired message to the rest of its citizens, or go Oklahoma Sooners. At some point there, Texas crossed the line and really was not engaging in Texas's speech, but it was selling really, really expensive license plates or really, really expensive bumper stickers where people could put their own messages on. But the lesson from the Alien and Sedition Act controversy and from many of these other controversies we discuss in Chapter 6, is that the Constitution is not the exclusive province of the courts. And the courts don't always necessarily get everything right, right? That constitutional interpretation is a game best not played alone, and that sometimes the corrective for wrong constitutional actions of any of the branches of the national government is counteraction by one of the other branches or even by actions of state government. That the correct interpretation of the Constitution emerges as a result of the separation of powers and the pull and tug of competing views, including citizens' views. What overturned the Sedition Act was the election of 1800 and the replacement of one political party by another political party. And that's a theme we carry through in our analysis of a lot of the controversies dating from 1789 to 2015, that the Constitution is ultimately a document that belongs to us, the people. Or you might say, we, the people, are the owners of the Constitution. And that's part of the mission of what we're trying to accomplish through this book, is that the Constitution is not the exclusive province of the lawyers, is not the exclusive province of the courts, but is ultimately something that belongs to all of us as citizens, and that we can all benefit from a knowledge and understanding of the Constitution's provisions and an appreciation of its rich and deep history. So thank you very much. I hope I've left 15 minutes or so for questions. Yes, sir.
I'm not an attorney or a constitutional scholar, but
Good for you. I've heard it said that Washington has more lawyers than people.
that's my wife. It's not me. I'm wondering if some Supreme Court decisions that have the force of law don't have the heft of other laws that are passed by the Congress. For example, Roe v. Wade. It wasn't passed by Congress, and it says that that abortion is legal, but it doesn't seem to have. I mean, it keeps getting attacked, and it seems to be much more vulnerable than laws that may have been passed by Congress.
Yes, that's an excellent point. Let me start by kind of trying to frame a way of describing the issue. When the Supreme Court issues a constitutional decision, it is not passing a law in the same sense that Congress is. It is purporting to interpret the text of the Constitution, and it is saying the text of the Constitution trumps any law that's contrary to it. So Roe versus Wade and many other controversial Supreme Court decisions is the Supreme Court's declaring that the Constitution says a particular thing and using it to invalidate what legislatures have done. Congress might have some abortion regulations. It does have some now. Roe versus Wade invalidated abortion restrictions or regulations of every state in the Union, and it did so based upon a purported interpretation of the Constitution, an interpretation that has remained, I think correctly, highly controversial. You know, Roe versus Wade is kind of your paradigm case of judicial activism. You know, whether you like the result, whether you hate the result, it is an illustration of the courts aggressively interpreting the Constitution in a way not really supported by its text and not really supported by its history or structure or even very well at all by its precedents. And, you know, this becomes really sensitive when we go through the modern era in our last chapter of the book, because so much of the modern era has been characterized, at least in its noteworthy constitutional decisions, by instances of activist judicial interpretation of the Constitution. Some of those interpretations are popular, others are very divisive. And I think it is justifiably controversial because when the Supreme Court, what do you do if the Supreme Court has said something is in the Constitution that isn't? Right? Is it, you know, it's very, very difficult to amend the Constitution, and why should you have to change the text of the Constitution if the Supreme Court has misinterpreted the Constitution in the first instance? And you hear this now with the same-sex marriage decision. You hear it perennially with many other decisions. Is it appropriate for the political branches and for the public and for the states to push back in various ways at what they think are the wrong decisions of the Supreme Court? Because when the Supreme Court reaches a constitutional decision, it is not the same thing as passing a law. It is purporting to be an interpretation of the document. And many of the court's interpretations over time, and we go through the whole history, they don't always get it right. For many years, Plessy versus Ferguson was the law of the land. Dred Scott was probably the most notoriously wrong Supreme Court decision in history and spurred in significant measure the rush to civil war. Other questions? Or are you afraid of being filibustered by the professor if you do? We have one here. Could you go to microphone?
My voice projects pretty well.
Actually, we have to do it for closed
Oh,
captioning.
okay.
Here, let me see if I can get it to you.
Oh, I can stay right here. Okay, okay. I'm not sure that I can state this correctly, but it has to do with the discussion in the Democratic debates recently, how often they brought up states' rights. And is this enough related to the Constitution? Okay. It seemed like states' rights were very popular on issues that they wanted to put in the hands of state government. But at the same time, there were other things that they didn't think should be left to the states that actually are. And what I'm thinking of, we're all from Washington State, and we have marijuana approval. We have a situation right now.
I do remember this from the debates.
Okay.
I caught that portion. Go ahead.
Okay. Where it was passed in the state of Washington, and then individual counties, sort of came in with their ideas. And we're in Douglas County, which is on the east side of the state, on the Columbia, and we have 3 representatives that about a week ago decided that Douglas County was not getting enough benefit out of producing 8% of the marijuana in the nation. I'm not sure if that's true, but that's what they say, and only getting 1% back in the way of restitution from the states. No excise tax is given back to it. And it was a majority decision of the 3 state representatives. How can they do that? How can they put a what do you call it? Moratorium. They just decided they were going to put a 6-month moratorium on any more production, selling, shops, whatever, of marijuana in Douglas County.
Well, let me try to disentangle that a little bit and only speak to things that I know anything about. Okay? Because I don't really know anything about Washington State's particular laws or anything. But let me speak generally. You made a couple of observations. One is that I think this is a universal observation. The Constitution is invoked selectively for political purposes, right? And it's done by both sides, and sometimes their arguments are right and sometimes their arguments are wrong. A faithful interpretation of the Constitution probably doesn't map onto any particular political agenda very well, right? I sometimes tell my students, if your interpretation of the Constitution produces results that track exactly your political preferences, you're probably not interpreting the Constitution. You're interpreting your political preferences. And so without speaking to what the politicians might necessarily have been doing that, it's often the case that people reverse their positions on the constitutional issue when the political view doesn't line up with theirs. So there's nothing too surprising about that. It's actually a common observation. The question of states' rights in particular is just a version of this Hamilton versus Jefferson debate over the scope of national power. where the national government has power and enacts a rule, it trumps any state rule to the contrary. There has to be a national power. And if so, that ousts what the state has done to the extent it's contrary to the national rule. It's part of a provision of the Constitution called the Supremacy Clause. This Constitution and the laws of the United States passed in pursuance thereof and treaties shall be the supreme law of the land, anything in the laws of the states or the state constitutions to the contrary notwithstanding. So federal law wins. Okay? Now, what's interesting about the marijuana controversy is the federal government administration right now, the Obama administration, has declined to enforce federal law where a state has said we don't want you to. And that's really a highly unusual and peculiar situation, but they've kind of given states an exemption from the application of federal law. And what I heard some of the Republican candidates talk about was debating whether or not that was proper. As president, will you enforce the national laws? As president, do you believe in states' rights? And then they went at each other back and forth. As to what the state representatives are doing and 8% of the revenue, I don't know a thing about it, so I can't comment on it. But it's a highly interesting question.
Could you go over a little bit of what your chapter on the Civil War says, please?
Oh, do you have another hour for me to talk about the Civil War? Chapter 7 is my favorite chapter of the book. I'm a huge Lincoln fan. I'm only in Washington for a couple days, but I have to make my pilgrimage to the Lincoln Memorial. And I'm hoping that one of my next books is on Lincoln and the Constitution. I've been teaching a seminar for a number of years on Lincoln, the Civil War, and the Constitution. Let me give you the briefest version. Okay? The Civil War, Luke and I argue in the book, it was fought over grand questions of constitutional interpretation, and is probably the most single important event of constitutional interpretation in our nation's history. Now, the Civil War was much else in between, but it was a war fought over constitutional meaning. You know, what is the status of slavery under the Constitution? Who gets to determine that status? Can slavery be extended to the territories? Must it be, as the Supreme Court held? What is the authority of a clearly wrong and abusive Supreme Court decision like the Dred Scott decision? Lincoln rose to prominence as a critic of the Supreme Court, calling for resistance to what he thought was a flagrantly wrong Supreme Court decision. His opponent in 1858 in the Illinois Senate race was Stephen Douglas, who was saying, if you oppose the Supreme Court's decisions, you are opposed to the Constitution. Lincoln said nothing of the kind. The Constitution permits the Supreme Court to decide cases, but it doesn't permit it to decide national issues for everyone else. Lincoln said that? Okay. Lincoln is eventually elected president, and the South secedes in part because it thinks it has lost the political battle, and in part because it thinks it is outrageous to have such an anti-constitutional, anti-Dred Scott president. The South secedes, and the great issue is, does a state have a constitutional freedom to secede? And that grand issue is decided not in any court, because you don't want the Supreme Court that decided Dred Scott deciding that the South can leave in order to preserve slavery. Instead, that great constitutional issue is decided on the battlefields. You know, it's not a Supreme Court case. It's the case of Grant versus Lee, settled at Appomattox Courthouse, Virginia, that resolves this great issue of constitutional interpretation. And then the Civil War produces, in its wake, 3 great constitutional amendments. The 13th Amendment abolishing slavery, the 14th Amendment protecting national civil rights from state interference and giving Congress power to enforce it, and the 15th Amendment banning racial discrimination in voting, that really transform fundamentally the nature of our constitutional order. You hear me getting excited about this chapter. Chapter 7, I've given a presentation someplace in New York, essentially on Chapter 7 on Lincoln and the Constitution. But I think Lincoln, as president, was the nation's single most important constitutional interpreter. And the Civil War, not any Supreme Court decision, was the nation's single most important act of constitutional interpretation. Thank you so much for your question. I love that question. And thank you very much for being a wonderful audience. It's been great to be here.
And don't forget, there is a book signing one level up at the Archives bookstore. We will meet you up there in just a couple moments. Don't be put off by the closed gates at the bookstore. There's